Premises liability is an important concept in California law that holds landowners responsible for injuries that occur on their property. Under California law, landowners owe different legal duties to different types of visitors. In this video, we will explore the different types of visitors recognized under California law and generally summarize the main points in premises liability law. Remember, this isn't legal advice. So, if you want to learn more, or see if your facts may be a case, contact a lawyer, like Gateway Pacific Law Group. You can visit us on our website, www.gpaclaw.com. Now, on to the video. What is premises liability? Premises liability is a fancy way of saying that a person was hurt on another person's property. In California, people who own or control property have a duty to maintain their property in a reasonably safe condition and to warn visitors of any hidden dangers that may exist. If a landowner fails to meet this duty and a visitor is injured as a result, the landowner may be held liable for the visitor's injuries. Types of visitors. Under California law, there are 3 types of visitors: invitees, licensees, and trespassers. Each type of visitor is owed a different legal duty by the landowner. Invitees. Invitees are visitors who are invited onto the property for a business purpose or for the benefit of the landowner. Examples of invitees include customers at a store or guests at a hotel. Landowners owe invitees the highest duty of care and must take reasonable steps to ensure that their property is safe. This duty includes inspecting the property for hazards, repairing any hazards that are found, and warning invitees of any hidden dangers that cannot be repaired. The next category of visitors are called licensees. Licensees are visitors who are invited onto the property for a social purpose, such as a party or a gathering. Examples of licensees include friends and family members who are invited over for a barbecue or a dinner party. Landowners owe licensees a slightly lower duty of care than invitees and only has to warn them of any hidden dangers that the landowner knows about or should know about. The final category are trespassers. Trespassers are individuals who enter the property without permission or authorization. Examples of trespassers include people who climb over a fence to swim in a private pool or burglars who enter a home to steal things. Landowners owe trespassers the lowest duty of care and generally do not have a duty to warn them of any dangers on the property. Although tempting, the law forbids landowners from intentionally harming trespassers or setting booby traps for them, like a gun with a trip wire or a hole in the ground with sharp stakes. You could be liable for the trespasser's damages. In addition to the duty to maintain safe premises and warn of hidden dangers, landowners owe visitors a duty to provide reasonable care. This duty includes taking reasonable steps to prevent foreseeable harm to visitors and to protect them from criminal activity that may occur on the property. For example, if a landowner knows that there is a high risk of criminal activity in a certain area of the property, they may have a duty to take steps to protect visitors from that activity, such as installing security cameras or hiring a security guard. If a landowner is found liable for damages in a premises liability case, the visitor may be awarded damages for their injuries. These damages can include medical expenses, lost wages, pain and suffering, property damage, punitive damages, in cases of gross negligence. If you find this video helpful, please take a moment to hit that like button down below. It really helps us out and lets us know that you find the content beneficial. And if you want to see more videos like this one, don't forget to comment on any future videos you'd like to see and click that subscribe button and ring the notification bell. That way, you'll be the first to know whenever we release a new video. Also, go to our Linktree link to check out all our social media accounts for even more legal information and humor. Now, back to the video. Property owners can assert many different affirmative defenses to try and defeat a premises liability lawsuit. The most common ones in California are, first, sweep sheets. This is a common defense used by property owners in premises liability cases. A sweep sheet is a record of when an area was last inspected or cleaned. Property owners may use sweep sheets to argue that they were not aware of a hazardous condition because it was not present during the last inspection. However, sweep sheets are not always a reliable defense. If a hazardous condition existed for a significant amount of time, the property owner may still be held liable even if it was not present during the last inspection. Another affirmative defense is called assumption of the risk. This is when the visitor knew about the hazard and voluntarily assumed the risk of injury. An example is when you break a leg landing while skydiving. However, if you're a new skydiver and the skydiving company packed the parachute wrong and it didn't deploy, that probably would not fall under assumption of the risk. And finally, there is the defense of comparative fault. This is where the visitor's own negligence contributed to their injuries. In California, the visitor's own actions may also be taken into account when determining liability. If the visitor was partially responsible for their own injuries, the court may assign a percentage of fault to them. This is known as comparative fault. In conclusion, premises liability is an important concept in California law that holds landowners responsible for injuries that occur on their property. Landowners owe different legal duties to different types of visitors, depending on their status. If you have been injured on someone else's property, it is important to seek legal advice to determine your rights and options for seeking compensation.